All right, thank you, Jenny. Appreciate it. Good afternoon, everyone. My name is Barry Wood. I'm the Assessment Division Director for the DLGF. I'd like to extend a special welcome to the PTABOA members that maybe don't participate in our normal webinar presentations. Just want to take a minute to say thank you for your service and for joining us this afternoon. So without further ado, today we're going to cover the PTABOA role and responsibilities, best practices, common issues and problems that we encounter, and then questions. And just as a disclaimer, the DLGF does not get involved in individual property tax assessments or appeals. The following information should not be construed as legal advice, and any legal questions or issues should be directed to your county attorney. So, having said all that, let's talk about the PTABOA role and responsibility. So, Indiana Code 6-1.1-28-1 allows the county commissioners to determine if they want a 3-member or a 5-member PTABOA. And just surveying counties over the past several years, it's been pretty evenly divided between the number of counties with a 3-member board versus those with a 5-member board. But it is a local determination whether or not you want a 3 or 5-member board to hear the appeals. Starting in January of 2017, the legislature did authorize the creation of multiple county PTABOAs. To my knowledge, we do not have any multiple county PTABOAs, but that would be a situation where maybe in the southeast part of the state, Switzerland and Ohio counties decided that they would be better off having just one PTABOA between the two counties instead of separate individual PTABOAs. So that has been authorized, but like I said, I don't believe there have been any created since 2017. In terms of who can serve on a PTABOA, one of the requirements, as you can see, is that that person must be knowledgeable in the valuation of property. There's no litmus test, no qualifications to say, testing me on this property term, that property term. It just says a person, an individual must be knowledgeable in the valuation of property. If your county does have a 5-member PTABOA, commissioners appoint 3 members. The county council would appoint 2 members. At least one of the members appointed by the fiscal body and by the commissioners must be a level 2 or 3. However, both the commissioners and the council may waive that requirement if they decide to. Then also for a 5-member PTABOA, no more than 3 of the 5 members may be in the same political party, and at least 3 of the 5 members are residents of that county. For a 3-member PTABOA board, the fiscal body appoints 1 individual and the commissioners appoint the other 2 members. The situation with this one is that not more than 2 of the members may be of the same political party, and at least 2 of the members must be residents of the county. In terms of the appointments, much like what we saw with the 5-member board, the commissioners and the council may waive that level 2 or 3 requirement. I mentioned the multiple county PTABOAs that were created, and this takes over place of the geographic area. And each PTABOA, each county PTABOA, you can see the requirements there that 3 members are not more than 2 of, if you have a 3-member multiple county PTABOA, not more than 2 of the 3 may be from the same political party. And if you have a 5-member multiple county PTABOA, not more than 3 may be of the same party. And the ordinance that's passed by the counties must specify the number of members for that PTABOA. So if you had back to Switzerland and Ohio counties, if both counties decided they wanted to have one joint PTABOA, they must specify, the ordinance must specify whether it's a 3 or a 5-member board. Each member of a multiple county PTABOA must be 18 years of age, and as I mentioned earlier, knowledgeable in the valuation of property. There are a couple of contingencies or restrictions. One is for a multiple county PTABOA. One is that a member individual may not be an elected county official. Member may not be an employee of a county or township that is in the geographic area within the jurisdiction. And here's a key thing I wanted to specify or to clarify. If you have a multiple county PTABOA, an appraiser in a county that is within that geographic area may not serve on that multiple county PTABOA. However, if you just have a single, countywide PTABOA, not a multiple county PTABOA, an appraiser can serve on the PTABOA, and in many cases, an appraiser may be a valuable resource in terms of the knowledge and information and experience they have with property values in that county. So an appraiser in this situation for a multiple county PTABOA cannot serve, but in all other situations, as long as that appraiser met the qualifications, they could serve on a PTABOA. In terms of the compensation for the PTABOA members, that's determined by the county councils for the participating counties. And the county that has the greatest population is sort of the one in charge of that multiple county PTABOA in terms of providing administrative support. So what is the role of the assessor with the PTABOA? First and foremost, I want to stress that the assessor is a non-voting member of the board. So they serve as the secretary, they attend the board meetings, obviously, but they are not to be a voting member, be it a 3 or 5 member board. They are not to be a voting member of that board. The assessor keeps full and accurate minutes of the proceedings and giving the date and time and place of the annual session that we'll talk about in a minute of the board. And then also the assessor should have an appeal tracking process. Typically, this is going to be done through your CAMA software vendor. They'll have a software program design that you're able to track your appeals in a timely manner. So per Indiana Code 6-1.1-28-6, there shall be, it's not a may, there shall be an annual meeting of the PTABOA, and you must give plenty of notice, obviously, because it's a public meeting. Most counties, if not all counties, will have their annual session in January. Typically, the council and the commissioners will appoint their members late November or December, and most, if not all, the counties will hold their annual meeting in the early part of the year, typically January. However, it's not required to be in January, but there is to be at least one annual meeting of the PTABOA. As far as other roles and responsibilities, now we're going to address or look at preliminary hearings. Assessors schedule a preliminary conference with the taxpayer at a time convenient to the taxpayer. And prior to the conference, the assessor and taxpayer exchange information. And if for whatever reason additional information is obtained after the preliminary informal hearing, but before the PTABOA hearing, that information must be provided to the other party, be it an hour afterwards or a day later or a week, whatever. If you or the taxpayer has additional information that was not presented initially in the informal preliminary conference, then that must be disclosed prior to the PTABOA hearing. If for whatever reason that information is not provided before the hearing and you get to the PTABOA hearing and all of a sudden it's the Perry Mason, here's the smoking gun, so to speak, the PTABOA shall continue the hearing until that receiving party has an opportunity to look at that information. That person could waive that continuance if they wanted to, but it would be a case-by-case situation. And regardless if there's additional information, the PTABOA shall hold, not a may, shall hold a hearing on the appeal not more than 180 days after the filing date of the written notice. So if June 15th is the filing deadline for the appeals, then the PTABOA shall hold a hearing on that appeal no later than 6 months or 180 days after that appeal is filed. The PTABOA is required to give at least 30 days notice of the hearing to the taxpayer, And if for whatever reason if good cause is shown, and that's not defined, but if good cause is shown and a taxpayer requests at least 10 days before the hearing in writing a continuance, then the PTABOA shall grant a request for that continuance. Conversely, a taxpayer may decide to withdraw their appeal, and they must do this at least 10 days before the hearing by filing a written request. If they do file a written request, that does waive the taxpayer's right to appeal to the Indiana Board of Tax Review. And then the PTABOA shall determine an appeal without a hearing if requested by a taxpayer in writing at least 20 days before the hearing. One of the biggest things I hear from taxpayers is, do I have to have an appraisal to file an appeal? And the answer is no. A taxpayer is not required to have an appraisal in order to file an appeal. And during the PTABOA hearing, the taxpayer shall have the opportunity to present their testimony and documentation and evidence. And if for whatever reason the PTABOA decides they need additional time, they may adjourn and continue the hearing to a later date to make a physical inspection of the property. And we'll talk about that in a little bit, or take time to consider the evidence presented. In some situations, the taxpayer or the taxpayer representative will not show up to the hearing or provide a request for a continuance. And so in that situation, yes, the county assessor may, it's not a shall, it's an option, the county assessor may assess a penalty of $50 against the taxpayer. And this is not, the penalty is not added or part of their property tax bill. It would be a separate billing situation for a penalty if it is applied, and a taxpayer may appeal that penalty to the Indiana Board of Tax Review or to the Indiana Tax Court. So I mentioned the 180-day time frame for the PTABOA to hold a hearing. If for whatever reason the PTABOA does not hold a hearing within 180 days since the appeal is filed, the taxpayer may initiate an appeal with the IBTR. They're not required to, but in some situations, a taxpayer may decide, hey, the county has had their 6+ months to deal with the assessment appeal and they haven't done anything, so I'm going to go straight to the IBTR. So that is a possibility if the county does not act on the appeal in a timely manner. In some situations, instead of having a hearing before the PTABOA, maybe the taxpayer and the assessing official decide to enter into an agreement where they agree to waive a determination by the PTABOA and submit their dispute directly to the IBTR. And by doing that, they're going to stipulate to an assessed value by an independent appraisal. And a couple key provisions to this agreement is, first, that you cannot enter into this agreement more than 120 days after the appeal has been filed. And if an agreement is entered into the two parties, the taxpayer and the assessing official, the PTABOA shall select 3 Indiana registered appraisers as potential appraisers, and then not more than 15 days after that, the taxpayer and the assessor may each strike one of the assessors if they decide that, hey, I don't think this appraiser would give me a fair shake. They can strike that person's name from the list. Not later than 60 days after that agreement, and an appraisal is conducted. And the appraisal, as you can see, must be prepared in accordance with USPAP, which is the Uniform Standard of Professional Appraisal Practice. It must be notarized and it must be filed with the PTABOA no later than 3 days after its completion. This does not prevent that either party, the township assessor or county assessor, or the taxpayer to retain their right to initiate an appeal with the IBTR, the Indiana Board of Tax Review. So if there is an independent appraisal, the PTABOA shall enter the determination of that assessed value to be that appraised value. So if the appraisal, say it's a residential appraisal, and the appraiser comes back and says the value is $150,000 based on the agreement, then that's what the assessed value would be that exact $150,000 amount. So what happens if you have an appeal and there's confidential information, confidential evidence? First, the hearing is probably going to be recorded. And if so, if the PTABOA receives confidential records or information such as income and expense information, or things like tenant list or whatever the case may be, meaning the PTABOA, must maintain that confidentiality of that information. The PTABOA can go into executive session to discuss the confidential information. However, the hearing should not be stopped just to start an executive session. As you can see from the code provision, excuse me, executive sessions may be held only in the following instances, and it says for discussion of records classified as confidential by state or federal statute. And in that executive session, the PTABOA may not take final action. So they go into executive session where the public is probably going to be dismissed, and only the taxpayer would be present to present the confidential information, but the PTABOA may not take final action in that executive session. The PTABOA is subject to the open door law, which is basically ensuring that official action is open to everybody and anybody in the public. You can see the PTABOA meeting is a gathering of a majority for the purpose of taking official action, and public notice of the date, time, and place must be given at least 48 hours prior to the meeting. So what is official action? It's fairly broad. It's not really well defined per se, other than you can see, what might constitute is, receiving information, deliberations, making recommendations, establishing policy, making decisions, and taking final action. One question we get frequently is, well, how much do we pay our board members, and what about policies in terms of board proceedings? Excuse me, I'm so choked up to be here. Compensation, those are local decisions. The board members shall receive compensation on a per diem basis. The county council is responsible for fixing the compensation rate. The assessor will keep records of the attendance and certify the number of days to the county commissioners. Especially with larger counties, the PTABOA may hire field representatives and hearing examiners to help the board perform its duties, especially if there is a large number of appeals that are filed. These representatives must be level 2 or 3 certified, and their compensation in the numbers is determined by the county council for that county. These representatives have the same powers as the board in terms of review of and hearings of the assessments. What the representative may do is meet with the taxpayer and come up with their findings, and then they report their findings to the PTABOA in writing, and the PTABOA can accept those recommendations, or they can say, hey, we want to have a further hearing and take additional evidence at that time. Regardless, the board makes the final decision on each matter. So even if a representative and a taxpayer reach an agreement, it's still up to the board to make that final determination. So the board has many powers. First is to subpoena witnesses. They can examine witnesses under oath on the assessment or evaluation of property. They can compel witnesses to answer questions, and they can order the production of relevant papers. Each year, the PTABOA, typically it's going to be the assessor acting as the secretary for the PTABOA is required to submit a report before April 1st via Gateway, and that is for the prior year's appeal activity, indicating the number of appeals filed, number of hearings conducted, decisions resolved, preliminary informal meetings, information meetings, the number of appeals outstanding, and how the appeals were resolved. There is probably going to be legislation introduced next year in the legislature that would change that April 1st deadline to maybe something closer to, say, the end of January, early February. And the reason that's probably going to be proposed is when the legislature is session, they want to basically have real-time data information. And if there is an April 1st deadline, especially during the legislature's short session, they may not have that information while they're meeting. So there's probably going to be legislation introduced that would change that April 1st date to an earlier date in the year. So what are some PTABOA best practices? The first is the golden rule. Yeah, that the PTABOA members should treat one another, taxpayers, assessing officials, how you would want to be treated. And even though the PTABOA is not a trial, a PTABOA member should conduct themselves, him or herself, like a judge would. The assessments are presumed to be accurate. However, if the assessment increases by over 5% from the preceding assessment date, the assessor has the initial burden of proof in the appeal. That's a key thing, is the initial burden of proof. If the assessor meets that burden of proof, then the burden of proof would then fall to the taxpayer to prove or show why they do not believe that assessment is correct. But if it increases by more than 5% from the preceding assessment date, the assessor has the burden of proof. So for determinations and decisions, it's by motion and majority vote. It's based on the evidence presented. There is always the possibility that the assessment could increase. Taxpayers typically think, hey, I'm going to appeal my assessment and it's either going to stay the same or it's going to go down. Well, there is the possibility that it could increase. If it does increase, then the PTABOA shall issue a written decision given to the assessor, the auditor, and the taxpayer. As we talked about that 180-day time frame a few minutes ago, if the PTABOA has not issued a determination before 180 days has passed, the taxpayer may, not shall, but the taxpayer may initiate an appeal with the IBTR. In regard to the preliminary hearings, the hearings for the with the PTABOA, can the assessor set a set amount of time for each hearing? Sure. In some cases, maybe it's a 15-minute time frame, 20-minute time frame, especially for residential properties. For more complex properties like commercial or industrial properties, maybe it's a little bit longer, a half hour or an hour. But this would be determined, by the PTABOA in terms of determining their procedural rules, how long they're going to allow each appeal to last. And part of that may just be based on the number of appeals filed and trying to get those processed in a timely manner. So if you're a PTABOA member, how do you decide that a prima facie case has been made? Well, it's going to be obviously based on the information and the documentation and the evidence presented, typically on a case-by-case basis. Each case is going to be different. Some may be very similar. You may have a taxpayer filing or a taxpayer representative filing similar appeals for multiple properties, but it is done on a case-by-case basis. If you are a newer PTABOA member, the Indiana Board of Tax Review and the Indiana Tax Court publish their decisions, and you can go online and read their decisions and find out what was a successful appeal. Why did a taxpayer win and not the assessor, or why did the assessor win and not the taxpayer? So those are good resources that could help you become familiar with what weighs heavily in a decision for the successful party. In some situations, it may be hard to find qualified individuals to serve on the PTABOA, and that's why some counties may have gone from a 5-member to a 3-member board. And a question has come up, can our prior assessors serve on the PTABOA? We are not aware of anything statutorily that would prevent this from happening. However, just from a perspective of public, a public point of view, public perspective, it may raise a few eyebrows. Somebody could say, well, the former assessor was responsible for my assessment. Now they're on the board and they're deciding my appeal, and of course they're going to support their own assessment that they did previously. So there's nothing preventing it, but you may want to look for potential other candidates before the prior assessor would serve on the board. There is a provision, however, that a former assessing official cannot serve as a tax representative in their former jurisdiction. So should the PTABOA visit properties on appeal? Well, in some cases it may be necessarily just to have a physical inspection, but if your county has a lot of appeals filed and you're trying to physically visit each property, there may be some time and budgetary constraints, especially if you're having to do a lot of driving and you have 3 or 5 members each driving separately. So there's nothing preventing it. It does allow a physical inspection, but it's something that you may want to use caution in terms of do you or don't you. And in this day and age of GIS and pictometry and people bringing in photos, maybe that might be a better way to address that situation. In terms of what constitutes a quorum for the PTABOA, the Indiana Code provision there states that a majority of the PTABOA that includes at least one certified level 2 or 3 assessor constitutes a quorum. However, the decision for an appeal is based on the majority of the quorum or the whole board. Which is it? And the code provision states that any question properly before the board may be decided by the agreement of a majority of the whole board. So you may have a situation where you have a quorum to hold the hearing, but you'd have to wait until you have a quorum of the whole board before making a decision. So I'm a taxpayer and I file an appeal. What do I need to file? What type of evidence do I file? As I mentioned previously, an appraisal is not required in the appeal process. However, many taxpayers have found that an appraisal does help their case, but an appraisal would cost money and take time. If an appraisal is completed, it must be USPAC compliant. Some taxpayers will submit their construction costs, both direct and indirect costs, the sale of the subject property, as long as it's an arm's length transaction, and that means that it was exposed to the open market. Neither party is operating under duress. There is no, family relationship in exchange for money. Things that go into a valid sale would be considered an arm's length transaction. And then sales of comparable properties. And in the appeal process, the sales of comparable properties is typically going to be where the focal point of the evidence in the case rests in terms of what is or what is not a comparable property. There are some provisions, especially as it relates to residential properties and the proximity of comparable properties. As you can see, this provision took effect after June 30th, 2012. But to accurately determine market value and use, a taxpayer or an assessing official may use sales comparable properties that are located within 2 miles of a boundary of the taxing district and in the same taxing district. In some situations, you may have to go beyond that 2-mile limitation, especially this is just for residential property, so it doesn't address, say, commercial and industrial properties, in which case that 2-mile proximity does not exist. But if you're looking for, what is or what is not comparable properties, you certainly want to look at this 2 mile boundary as a litmus test. If a taxpayer presents evidence or documentation, an assessor just can't simply say, hey, I think this is wrong and I don't think it's valid. They would have to be able to, the assessor would be able to have some way to challenge it and show that, hey, it's wrong for whatever reason it may be. Back to the comparable properties, maybe the assessor says, I don't believe this is a comparable property. It's a 5,000 square foot home versus a 1,800 square foot home, or it's beyond that 2 mile boundary limitation and things like that. The main thing is that the assessor would have to challenge specific flaws in the evidence and or submit evidence to show that here's why, here's to show the flaws. Maybe you're looking at, a house with a pool compared to a house without a pool as a comparable property. And the taxpayer did not take that into an adjustment for that pool into consideration. So things like that. But typically the determination whether or not they're comparable is based on accepted appraisal and assessment practices. Appraisals it's an opinion of value. So the assessor needs to analyze the sales being used. And then also the adjustments being made. I mentioned a minute ago that pool, and so you have the subject property has a swimming pool, and there are 3 or 4 or 5 comparable properties without a pool, and the appraisal does not account for or adjust for that swimming pool for the comparable properties. That's something that an assessor could challenge. Also, there are some properties that say income producing properties where the taxpayer submits income and expense statements, and in that situation maybe the assessor challenges some of the expenses that are claimed, or maybe they challenge the capitalization rates that's used. And then also some property types, like say golf courses, for example, they are statutorily required to use one of the 3 approaches. In this case, golf courses are required to use the income approach to value. So how should these informal hearings or PTABOA meetings be held during the pandemic? And many counties have gone to doing these remotely, virtually, doing Zoom or Microsoft Teams. Other counties that have proceeded in person, making sure they take certain precautions, social distancing, wearing masks, that type of thing. But it'd be up to the local officials, up to the PTABOA, how and when they would want to conduct the hearings based on COVID. So who can file an appeal? Well, basically it's the taxpayer of record on the assessment date. So January 1st is the assessment date. The property owner owns the property January 1st, 2021. They would be the ones that would file the appeal. However, the IBTR, the Indiana Board of Tax Review, has previously ruled that if somebody may not have owned the property on the assessment date, but they're responsible for the property taxes for that assessment date, that they would have standing for the appeal, for filing an appeal. In some situations, a taxpayer may not file an appeal timely. So what do? Everybody wants to have their day in court, so to speak. So a taxpayer could go ahead and file the appeal, but they should be well aware that even though they're filing it, it's not timely, and they're probably not going to be successful. The legislature over the past several years has taken steps to make it easier for relatives to file or to represent a property owner in the appeal process. So an owner of a property filing a power of attorney may have a relative represent them at the PTABOA level, but not the IBTR level. So if you can see the list of relatives, spouse, parent, child, aunt, uncle, so forth. Those individuals could represent the taxpayer in an appeal proceeding at the PTABOA level, but not at the IBTR level. What about CPAs? A CPA can represent a taxpayer in an appeal for personal property taxes, but they cannot on real estate taxes, real property. As we talked about, I talked about a few minutes ago, can an assessment increase as a result of an appeal? And the answer is yes. That there are sometimes through the course or conduct of filing an appeal that there are things that were either undervalued or omitted, and those properties can be increased within 3 years, a 3-year period of time, as long as proper notice is given to the taxpayer. The assessing official, however, should be prepared to defend the increase. So if I'm a taxpayer and I file an appeal and all of a sudden my assessment increases and I get a notice saying my assessment increased, I'm going to be saying, well, why did it increase? And maybe it was the assessor went out to look at the property and noticed that the taxpayer had built a new pole barn that they did not have on their property records. And so they picked that pole barn up and assessed that taxpayer. So an assessment can increase as a result of the appeal, but if it does increase, like I said, the assessing official should be prepared to defend that increase. So what's the difference between a Form 11 and a tax statement? So first off, a taxpayer must file a separate petition for each parcel, and it may be filed anytime, or depending on when the assessor sends out or does not send out a notice of assessment. So January 1st, 2021 is the assessment date, and on or before May 1st, say by April 30th, the assessor sends out a notice of assessment, Form 11, to the taxpayer. If the assessor sends out the notice of assessment before May 1st, then that taxpayer would have until June 15th of that year to file the appeal. So January 1, 2021 assessment date, notices of assessment Form 11s go out April 30th, 2021. The taxpayer has until June 15th, 2021 to file an appeal. If for whatever reason the taxpayer does not send out, or the assessor does not send out a notice of assessment, and even if it's May 1st or May 2nd, or if they decide that the tax bill will serve as the notice, then the taxpayer would have until the following June 15th to file an appeal. So January 1, 2021 is the assessment date. The assessor does not send out a notice of assessment timely or at all, then the taxpayer would have until June 15th, 2022, a year later, to file an appeal for that 2021 assessment date. So I've said a lot. And so with that, Jenny, do we have any questions?
We have a quiet bench today, so no questions at this time. Can you go over some of the ones that were reviewed this morning?
Sure, be more than happy to. And before I do that, if you do have any questions after this presentation, there's my contact information, phone calls, emails. Be more than happy to try and answer any questions that you may have. So with that, some of the questions that have come up previously. First question is the information filed with the PTABOA for an appeal available to the public? Typically, that information is going to be publicly available. However, there may be some documentation or some things that are confidential and would need to be redacted. By that, I mean, say you have a commercial property owner that files an appeal, and as part of their appeal, they include their income and expense information. Typically, that's going to be confidential information and would need to be redacted before it could be disclosed. If you do have a question on what is or what is not public information, public documents, the state of Indiana has a public access counselor. His name is Luke Britt, B-R-I-T-T, Luke Britt, and he would rule or offer an opinion in terms of what is or what is not considered confidential information or what is available for public inspection. You could also check with your county attorney if you had any questions, but Luke is very good in terms of responding to inquiries and as far as what is or what is not public information or what is available or could be available to the public. So the next question is regarding the 180-day rule. How does that apply when you have reached out to the taxpayer multiple times by phone and letter, but there's no response? In this situation, the assessor got tired of waiting, and the taxpayer had filed their appeal in April. So the assessor went ahead and put them on for the roster, for the PTABOA hearing in November. So in some situations, for whatever reason, it may be difficult to get a hold of the taxpayer, and obviously you try the best you can multiple times, be it call, write, email, whatever the case may be. But for some situations, some reasons, the taxpayer may not appeal, and you have to go. You can't let the appeal just be idle. So in those situations where you may not be able to get a hold of the taxpayer after repeated attempts, then you may just have to go ahead and schedule the appeal. And if the taxpayer is able to finally show up, hopefully they do. If not, then you would send them the determination. And if they decide to appeal to the IBTR after that and say, hey, I never received notice, I think the assessor would be in a good place in terms of standing to say, well, here are all the times we reached out to the taxpayer and they never responded to us, and how do you, we tried our best and they didn't respond, so that's why we had to go ahead and proceed with that information. Let's see.
Barry, we had another question come up just now.
Sure.
Okay, the next question is, under what conditions would a PTABOA hold an executive session, essentially asking the public to leave the room?
Okay, let me go back in time if I can. And, get there. I'll get there. Oops. I'm too far. I think I'm getting there, hopefully. Going past it. So while I'm looking for this, so basically going into executive session may, I've gone past it, darn it. Okay, I'll just talk off the top of my head. So going into executive session is typically going to be done on a rare occurrence, and by rare I mean it should not be done on a, there we go. Should not be done, seemingly on a every appeal hearing basis. It would be, as you can see, executive sessions per this Indiana Code citation. Executive sessions may be held only in the following instances. And it says, for discussion of records classified as confidential by state or federal statute. And to that, what is confidential by state or federal statute? Generally, those are going to be things like income and expense information, things that if I were a property owner, for a commercial property, I would not want my competitors to know what my income and expense information is, or a list of my tenants, things like that. So you can go to that Indiana Code citation to find out specifically what's included, but as it's abbreviated there, it states that it's classified confidential. And like I said, that would be generally going to be things like income and expense information, to go in. If I were a taxpayer, I would not want my competitors to know, here's how much I'm making or losing, and here's my tenant roll list or anything like that. Any other questions, Jenny?
Yes, we have another one. What are the proper means and amount of notice for the public about future PTABOA hearings? I currently advertise in 2 local papers. Should this be announced on TV and radio as well?
So the open door law doesn't really get into specifics per se, other than you can see public notice of the date, time, and place of any meeting must be given at least 48 hours prior to the meeting. I mentioned at the start, I'll go back to the start with the with the annual meeting. It talks about giving notice 2 weeks before for the annual meeting, not the, say, a regular PTABOA session. It talks about the annual meeting, you know, in 2 newspapers of general circulation in the county, if there are 2 newspapers. Most assessors, you know, most counties probably only have 1 newspaper, so you would want to advertise the annual session in the newspaper and on your website. But in answer to the question, you know, for the regular PTABOA sessions, advertising in the newspaper would suffice, and then also posting a notification on, say, on your door, the courthouse door would suffice, and on your internet website if you wanted to do that. But I don't believe you would be required to go as far as to advertise on the radio or local television. I mean, you're not prevented from doing so, but that's going above and beyond the call of duty. So I think just meeting that criteria for posting the notice in, you know, at least, you know, on your door, the courthouse door, on your website, and then, you know, if you do have time to advertise in the local paper, that's fine. But I don't believe you need to go as far as doing it on local radio or television unless you wanted to. So, any other questions come up yet?
Yep, we have another one. Can commissioners and council waive the same political party rule?
Good question. I think we're going to need to follow up on that one to get a definitive ruling on that from our legal counsel. I get back to, okay. I'm not sure. I know obviously you can see, say, like for the 5-member waiver, 5-member board waiver for the level 2 or 3, you know, by the commissioners and the council. I'm sure I know that applies to the you know, do you have a level 2 or level 3? But I'm not sure if that waiver would also include the political representation as well. We'll have to follow up on that one. I don't want to speak out of turn, so to speak. So good question. I don't know. So we'll get an answer for that one.
Okay, that's all the questions that we've had submitted so far. Okay.
Then I'll go back to some of the other questions that we received. So you say a PTABOA member may not be an appraiser operating in the assessment market area. Do you mean an active appraiser? What about retired appraisers or inactive appraisers? I mentioned this earlier, but I'll reiterate. So this is that requirement, you know, that an appraiser cannot serve on a PTABOA is only applicable if you have a multiple county PTABOA. And you can see number 3 there. It says an appraiser defined by the Indiana Code citation there in a county that is in the geographic area within the jurisdiction of the multiple county PTABOA. So if Switzerland and Ohio counties has a multiple county PTABOA, an appraiser that lives in either Switzerland or Ohio County could not serve on that multiple county PTABOA. However, since Switzerland and Ohio counties have their own separate PTABOAs, then an appraiser living in Switzerland County could serve on the Switzerland County PTABOA, or they could serve on the Ohio County PTABOA. So that restriction is only on appraisers where there's a multiple county PTABOA. Appraisers certainly would bring a lot of wealth in terms of information, experience, and knowledge to a PTABOA. I know several counties do have appraisers, and it doesn't matter if it's an active appraiser or a retired appraiser or an inactive appraiser. I think an appraiser would bring a lot to a PTABOA. And in some situations, maybe you have maybe larger jurisdictions have an appraiser that's well versed or concentrates on residential properties, and maybe you have an appraiser that's concentrating on industrial and commercial properties, and so there's no restriction in terms of the retired appraiser. It just goes back to what I said at the start, is that a person just must be knowledgeable in the valuation of property. So other questions here in the last closing minutes. A question that was not from this morning, but has come up in the past couple of weeks that I received is, how many continuances can a taxpayer request? Talked about, if a taxpayer makes a request, for if good cause is shown, the PTABOA shall grant a request for continuance filed in writing at least 10 days before the hearing and rescheduled hearing. So what happens if you have a taxpayer and they file a continuance and you grant it, and then they come back a month later and say, oh, I need another continuance, and you grant that? At what point do you say, you've had one or two opportunities, we're not going to give you any more? There's no hard and fast rule to that. It just depends on the circumstances and the situation. Given COVID, maybe there's something that comes up that prevents a taxpayer from attending. So you'd have to take it under advisement in terms of how many continuances you grant a person. But I would think anything more than two, unless it's very, very extenuating circumstances, anything more than two continuances, you'd want to contact the taxpayer and say, hey, what's going on? But yeah, you just have to look at it case by case. Another question that I've had is, when should a PTABOA member recuse themselves, him or herself? So you have a PTABOA member, and maybe they have an interest in a property, or maybe they had a former interest in a property, be it as an owner or whatever the case may be. There's no rule per se, except for dealing with abatements, but there's no rule per se that a PTABOA member has to recuse themselves. But if it were me, and say, I'll just make up an example. Say I had an ownership in an architectural firm, and the architectural firm was appealing their assessment. Just again, from the court of public perception, it would look pretty bad if I were ruling on an appeal that I have a vested interest in. So it would be up to the PTABOA member to recuse him or herself if they believe so. But if they did not, and the taxpayer was not successful in their appeal, I would think they would have a case to make to the IBTR saying, hey, I appealed, and this PTABOA member had a vested interest in the situation, and they did not recuse themselves, and I think I should get a different determination. So it would be up to the individual to make that decision. So Jenny, I know we're getting close to the time. Any concluding comments you want to make?
Sure. And just a quick reminder that we will send out the PowerPoint, the video, the CE form and the survey tomorrow, so you can look for that. Again, you can share that with fellow PTABOA members or other assessing officials or other officials that would find this useful information. And then also please complete the survey. We do take that information seriously and review those, and we will begin planning for 2022 in the next month for the webinars. So we always appreciate great feedback as far as other topics that you would find like for us to cover. So thank you again for participating today. We appreciate your attendance.
Thank you, everybody. And if you do have any questions, like I said, please feel free to reach out to me, and hopefully I can provide you some information, documentation, answers that will help you. So enjoy your afternoon. Goodbye, everybody.